I sat in the same seat I was sitting in this morning, and I think I was sitting in that seat when I heard Alger Hiss give the lecture at the law school. We used to play bridge in the basement, but it's all different. The law school is different. Now, there's a room there. We all brought our lunches and ate lunch together down there. We'd play bridge and play as fast, maybe for 20 minutes, half an hour or so. And Dean Greene found out that we were doing this terrible thing, and he entered an edict that forbid all card playing any time or on the law school premises. And so our card games came to an end. Art Cedar, both of us were interested in getting into the practice as promptly as we could. The choice was between 1 year with Wiley Rutledge starting in the fall of '47 and 2 years with Chief Justice Vinson starting in the fall of '48. And so the winner of the coin flip was going to get to go with Rutledge rather than Vinson. And I remember when we did it in the law review office, and Willard Pedrick and Willard Wirtz were the two faculty members that supervised the whole operation. They basically said that the decision is so close, we'd like the two of you to make the decision. And Art and I both wanted the one rather than the other, but I won the coin flip. And we've talked about it often since then. We remain very good friends. Art is a very wonderful person, was a wonderful lawyer, but we started in different directions at that time. I think the entire faculty, when I was a student, was probably under 10 professors. Well, it's just the same advice you give every young lawyer. You do the best you can to understand what your job is and what the issues are and think them through, and just try to be honest with yourself and with the people you work with. But I was fortunate to work with people that I totally respected and enjoyed their company. Yeah, I'll miss my colleagues because they are, or to a person, they were wonderful people. They're good friends. We disagreed very seriously on issues from time to time. What I really will miss is not so much the work, but the day-to-day contact with my colleagues.
It's an honor to be asked to discuss the legacy of a man who had so great an impact. Justice Stevens was the author of several momentous and consequential separation of powers opinions in the last 30 years, particularly Chevron. Another very important case that Justice Stevens wrote was Clinton against City of New York.
There is also a strong theme in Justice Stevens' opinion about the need to protect minorities, and especially adherence to minority religions.
In United States versus Lee, the court rejected a free exercise claim by the Amish to opt out of the Social Security system. Here's Justice Stevens concurring in the judgment. Quote, "In my opinion, the principal reason for adopting a strong presumption against such claims is not a matter of administrative convenience. It is the overriding interest in keeping the government, whether it be the legislature or the courts, out of the business of evaluating the relative merits of differing religious claims. The risk that governmental approval of some and disapproval of others will be perceived as favoring one religion over another is an important risk the Establishment Clause was designed to preclude." Close quote.
On these issues, the court has indeed veered sharply to the right, I think. And Justice Stevens has stayed from the beginning until the end, firmly rooted in what was once the center, should be the center, but is now the left.
Later in his career might have been called a legal realist. Surely the kind of monikers that we saw, lion of the liberal wing, leader of the liberal wing, all these kinds of things. He was not a legal realist in the way that Douglas was. He was not utterly unmoored from everything except what he personally felt on that particular day. I would like to put forward the concept of John Paul Stevens as an originalist.
Hearing here the individual judges voting in panels in which Stevens sat compared to their voting in the randomly selected cases. And what I think this table shows is that Judge Stevens truly was the median voter on the Seventh Circuit this time. and that in fact his impact was potentially profound. Now you have to buy into the random selection of cases here, but it suggests that the liberals moved more to the center when they sat on cases, on panels with Judge Stevens, and the conservatives even were willing to come to the center as well when they sat on panels with Judge Stevens. And I'm thinking of this in terms of sort of Judge Stevens, Justice Stevens, then judge obviously, magnetic impact or effect on the court in the sense that he brought the court closer to the center.
But I think his ability to perceive the legal weak spots in various arguments greatly strengthened the Supreme Court as an institution while he was there, because it kept everybody else on their toes.
Justice Stevens is often considered the judge's judge. In many opinions, he extols the ability of judges to make fine-grained distinctions in what one might say is a common law-like fashion. For unlike someone such as Justice Scalia, who claims to endorse a jurisprudence of rules, Justice Stevens endorses a jurisprudence of reasons. Perhaps most famously, he has said there is only one equal protection clause, one that requires legislation according to valid, publicly regarding reasons, and not merely rent-seeking or ox-goring.
Justice Stevens, in a characteristic case lawyering move, took some earlier cases and drained them of most of their meaning and gave them a new meaning, something common lawyers do. But they can't do, at least can't do honestly, if they really believe that their prior cases are like statutes, are absolutely fixed verbal formulations until they are changed by overruling, which Justice Stevens did not do to any of those prior decisions.
I want to conclude by talking about another aspect, what I hope will be Justice Stevens' most long-lasting legacy. And it's one that hasn't been mentioned yet, but I hope will get a lot of attention throughout the day. And that's the tremendous decency that he brought to the bench. I certainly felt this as a lawyer who argued several cases before him, including, I guess I should mention, on the losing side of Van Orden versus Perry. I saw it even more in the many arguments that I got to watch while sitting in the courtroom. Every lawyer was treated with such humanity and decency. But even more important, I think that this decency was reflected in the opinions that he wrote. Over the time that he was on the court, other justices increasingly came to use sarcasm in a poison pen. As I read Justice Stevens' opinions, I see that there's never such sarcasm. He never wrote with a poison pen. There was always a civility to his opinions and always a respect, even how much he vehemently disagreed. I hope that this is the model that will be followed by other justices and by lawyers and law students for years to come. I hope this will be one of his long-lasting legacies to the Supreme Court.
Justice, you are obviously quite famous for writing a lot of dissents, and in some instances 8-to-1 dissents. Actually, the first case I argued at the court, you wrote a dissent that was 8-to-1, and your opinion was substantially longer than the majority opinion was in that particular case. It was McNally versus United States.
Oh, right, yeah.
If you remember that.
Was I alone in that? Yeah.
You were alone.
But Congress agreed with me.
Well,
later.
That was only based on a very extensive reading of the legislative history, candidly.
Well, they amended the statute to adopt the position I advocated in dissent, didn't they?
Yes, that's true. But
are there dissents, are there majority opinions that you've written that have had impacts that you might not have anticipated, and such that you would have written the opinions differently potentially had you foreseen their consequences? No. Justice, so when Justice Scalia addresses crowds, he frequently throws down something of a challenge, which is, for critics of originalism, it's impossible, you can't fight somebody with nobody. So he sort of says the burden is on originalism critics or skeptics to sort of come forward with their affirmative case against originalism or in favor of an alternative. So I was wondering if you would respond to that, whether that's a proper framing, and if so, sort of what kind of response, if any, you would give.
Well, I've always agreed that you have to do your best to find out as much as you can about the reasons the law was adopted. And I don't think there's a distinction between federal statutes or congressional provisions. In either event, you want to look at the history and know as much about it as you can. And I've always thought there was a sort of strange contrast. Justice Scalia is very scholarly and accurate advocate of finding out everything you can possibly find out about the reasons for constitutional provisions being enacted. And I don't know why that reasoning doesn't apply to legislative sphere just as well. You want to know as much as you can.
All right, so Justice, this is a question I wanted to ask you for a long time. Can you tell us, when did you decide to start wearing the bow tie?
Well, the honest answer is I don't know. But I was asked earlier in an interview this afternoon is why I had the bow tie. And the real reason is my dad taught me how to tie bow ties, and it's just like tying your shoes. It's really pretty easy. But I always had trouble with the foreign hands. And when I tried to tie them, the narrow part would always get around in front. And so I just gave up on it.
Justice Stevens is a true Chicagoan, born and raised on the south side of Chicago in the Hyde Park neighborhood. He had served in the Navy as a part of a code-breaking team that was based at Pearl Harbor.
Now, Justice Stevens he had this balanced humility, was in keeping with the dignity that he showed everybody in his life, whether those who worked with him in chambers or those who appeared before him in court. One of the former clerks, one of my colleagues, said that if the justice was the manager of a gas station, people would be lining up around the block to work for him, because such was the experience of learning so much from his humanity and his use of power. Now, another major lesson that Justice Stevens taught his clerks, beyond this idea of courage, through the force of his own example, was that power, immense power, of course, is no excuse for arrogance or lack of compassion for all. There's a wonderful story about a man with whom the justice played tennis in Fort Lauderdale for many years. The man was a retired lawyer. And as the story goes, the man knew the justice as Jack, never had any idea who he was. And in fact, when one person walked by and said, "By the way, is that Justice Stevens you're playing with?" The story goes the fellow scoffed and chuckled. "Yeah, right, that's Jack. That's my friend Jack." And again, that's the justice's humility, the idea that he would know someone, play tennis with someone for all those years, and never let on the idea of who he was and that gravitas.
Thank you very much. It's a very moving occasion, as you can understand. There are an awful lot of things I feel I should say, but I can't cover them all. But one thing that I think maybe is evidence, I want to thank Dawn, of course, too, for the very generous remarks. But I think everybody here will agree that one thing I really did well as a justice and as a judge was pick good law clerks. There's no doubt about that. I have often thought that I received a vertical legal education that emphasized the importance of procedures that identify the correct decision maker, rather than a horizontal education that emphasized the rules that govern the conduct of law-abiding citizens. While we cherish the principle that we live under a government of laws, not of men, we also must recognize that specific applications of the law are the product of decisions made by executive officers and by the men and women who serve as jurors and judges. Identifying the proper decision maker is central to the administration of our system of justice. Finally, and of most importance, because every lawyer, sooner or later, confronts an unforeseen temptation, remember that your most valuable asset as a member of the legal profession is your integrity. If your adversaries and colleagues know that your word is good, you will be a successful lawyer. Congratulations and best wishes to every member of the class of 2011.